All right, I'm about to read the Colorado Rules of Evidence. This is basically an explanation of why it's so easy to railroad somebody when there's nobody else in the courtroom on their behalf. There were people that wanted to be there but couldn't afford to, and there were other people who showed up, but they just kept on continuing the court date. They basically did everything they could to prevent anybody from showing up. The evidence that is admissible, basically they can admit or not admit anything that they want, and a judge can choose to be excruciatingly biased in such painful ways. And I'm going to read those rules now so that you can understand how, well, loosely and stupidly it's written. Rule 101. These rules govern proceedings in all courts in the state of Colorado to the extent and with the exceptions stated in Rule 1101. Rule 102. Purpose and construction. These rules shall be construed to secure fairness and administration, elimination of unjustifiable expense and delay, and promotion of growth and development of the law of evidence to the end that the truth may be ascertained and proceedings justly determined. All right, that's 102. And then 103 basically just tears 102 apart. Rule 103, rulings on evidence. Effect of erroneous ruling. Error may not be predicated upon a ruling which admits or excludes evidence unless a substantial right of the party is affected and 1. Objection. In case the ruling is one admitting evidence, a timely objection or motion to strike appears of record, stating the specific ground of objection if the specific ground was not apparent from the context, or 2. Offer of proof. In case the ruling is one excluding evidence, the substance of the evidence was made known to the court by offer or was apparent from the context within which questions were asked. Once the court makes a definitive ruling on record admitting or excluding evidence, either at or before trial, a party need not renew an objection or offer of proof to preserve a claim of error for appeal. Record of offering and ruling. The court may add any other further statement which shows the character of evidence, the form in which it was offered, the objection made, and the ruling thereon. It may direct the making of an offer in question and answer form. Hearing of jury. In jury cases, proceedings shall be conducted to the extent practicable so as to prevent inadmissible evidence from being suggested to the jury by any means, such as making statements or offers of proof or asking questions in the hearing of the jury. D. Plain error. Nothing in this rule precludes taking notice of plain errors affecting substantial rights, although they were not brought to the attention of the court. Rule 104 helps tear rule number 101 apart even further. Preliminary questions. Questions of admissibility generally. Preliminary questions concerning the qualification of a person to be a witness, the existence of a privilege, or the admissibility of evidence shall be determined by the court, subject to the provisions of subdivisions B. In making its determination, it is not bound by the rules of evidence except by those with respect to privileges. B. Relevancy conditioned on fact. When the relevancy of evidence depends upon the fulfillment of a condition of fact, the court shall admit it upon or subject to the introduction of evidence sufficient to support a finding of the fulfillment of the condition. C. Hearing of a jury. Hearings on the admissibility of confessions shall in all cases be conducted out of the hearing of the jury. Hearings on other preliminary matters shall be so conducted when the interests of justice require or when an accused is a witness, if he so requests. D. Testimony by accused. The accused does not, by testifying upon a preliminary matter, subject himself to cross-examination as to other issues in the case. E. Weight and credibility. This rule does not limit the right of a party to introduce before the jury evidence relevant to weight or credibility. Um, Basically, there's just miles and miles and miles of this stuff. And it all is written as loosely as possible with some very stupid words. You could write this in simple English, even with those big complicated words to try to twist it all out of context. Basically, what it's saying is that we want to make it right, just, and fair, except that we can make it not right, just, and fair if we so choose, unless there are certain, well, blah, 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 blah. That's the end of this one.